Imagine you are a lawyer in New York in 1930s. You've just taken on a massive case representing hundreds of workers injured by a factory's negligence. You don't get paid a cent unless you win. But if you do, you take 30% of the damages. High risk, high reward. That's the American contingency fee system. It's a cornerstone of US litigation culture. Lawyers back themselves, take the risk, and if they win, they take a percentage of the payout. It's why you see those "we don't get paid unless you win" ads pasted across US billboards. But here in Australia, things work very differently. Our legal ethics and laws prohibit lawyers from charging a contingency fee based on the outcome of a case. Instead, they can use no win, no fee, but that only defers their hourly rate. They can't take a cut of the winnings. So if you are an ordinary Aussie wanting to take on a big company, you still need someone to fund that fight. That's where litigation founders come in, private companies that pay the legal costs up front in exchange for a percentage of the payout. And that business model, the whole structure of modern class actions, has just been shaped once again by the High Court's decision in the Kane and IMB case. So let's start with the basics. A class action, also called a representative proceeding, happens when one or more people bring a claim on behalf of a large group who suffered a similar loss. Maybe it's 40 airbags, underpaid wages, or misleading bank fees. It's sufficient instead of 10,000 separate lawsuits. You get one big collective case. But there is a catch. Class actions are incredibly expensive. Expert reports, evidence gathering, lawyers, barristers, all of that costs millions before you even reach trial. That's why litigation funding becomes a key part of the system. A funder steps in, pays the bill, and in return takes a commission, often 20% to 40% of whatever the group wins or settles for. For instance, Shine Lawyers in this case is a well-known litigation funder in Australia. As a listed company, it specializes in evaluating and managing no-win, no-fee cases. Originally, this was simple. Funders only got paid from people who actually signed funding agreements. But that led to an awkward situation. Some group members had signed and had to pay the founder. Others haven't signed but still benefited from the case. That didn't feel fair, right? So courts started using something called a common fund order, or CFO. A CFO enables the court to say everyone who benefits from the win contributes a fair share to the funder. Sounds reasonable, right? Everyone who gets a slice of the pie helps pay for the cost of baking it. Let's rewind through the key legal battles that set the stage for Kane. In 2016, the federal court in the Money Max case made a big move. It approved a CFO early in the case, before the outcome was known. The idea was to create fairness from the start. That decision boosted the litigation funding industry. Funders finally had predictability. They could invest in cases knowing the court might later spread the costs across the whole group. But then came the bombshell. In 2019, in Brewster case, the High Court said, hold on, courts don't have power to make CFOs at the beginning of a class action. Why? Because Section 33ZF of the Federal Court Act only lets court make orders necessary to ensure justice, not to create commercial arrangements. In other words, courts aren't supposed to design business deals for funders. That ruling caused some level of chaos and confusion. Funders were left uncertain. Lawyers scrambled to find workarounds. Many cases stalled or became less viable. To adapt, courts used funding equalization orders, also called FEOs. These didn't create a new contract. They just adjusted the final payout so unfunded members didn't get a free ride. But FEOs didn't guarantee funders a return, especially if people settle early or drop out. So from 2019 to 2024, litigation funding lived in a kind of legal twilight. Everyone, lawyers, funders, courts, was waiting for clarity. And then came Kane and IMB Investments. So what was Kane all about? The case involved a shareholder class action one of those big corporate claims where thousands of investors were grouped together. The issue wasn't about who was right or wrong in the corporate dispute. It was about how the settlement money should be divided once the case was done. The founder had supported the action, paying all the upfront costs, but many class members hadn't signed any agreement with the founder. So the founder asked the court to make a common fund order, not at the start of the case, but after it had settled. The key question for the High Court was, can a court make a common fund order at settlement approval stage under Section 33V of the Federal Court Act? The High Court said yes, but with very clear boundaries. It ruled that courts cannot make early CFOs to create funding structures. That's what Brewster already decided. But courts can make CFOs after the case is over, if it's necessary to ensure the distribution is fair and reasonable. Court relied heavily on Section 33V, which requires a class action settlement to be approved by the court. The judges said that fairness doesn't just mean looking at the total amount, it means making sure the distribution between the plaintiff, group members, and founders is appropriate. In practical terms, the court recognized that litigation founders take real financial risks, and without them, many class actions would never exist. But it also warned that founders shouldn't walk away with excessive profits. So the decision balanced two goals. Firstly, access to justice, keeping funding viable, and secondly, protection of group members, ensuring fair distribution. The majority opinion emphasized that the court's power isn't about helping founders, it's about supervising the settlement process in the interest of justice. So why the reasoning of this case matters? The reasoning in Kane restores some stability to the class action landscape. It confirms that courts remain the gatekeepers of fairness in class actions. Funders can recover their fees through the court orders, but only at the end, once the outcome is known. Lastly, the commercialization of litigation is acceptable as long as it's under judicial supervision. In short, the High Court draw a line. You can't pre-approve a business deal at the start, but you can make fair adjustment at the end to ensure justice is done. That sounds subtle, but it's a massive clarification for lawyers and founders alike. So what are the implications of the Kane decision, and what happens now? For litigation founders, it brings back some certainty. They now know that courts can approve a CFO, just not at the very start. That means the business model for litigation funding remains viable, but it also means the founder will have less certainty as to whether a CFO will be granted until the end of the case. You can take that as a yellow light, not to go wild, but to re-enter the space with some confidence and precaution. For plaintiffs' lawyers, it means more flexibility in settlement restructuring. The court can ensure fairness across the whole group, so non-signing members still contribute proportionally. Therefore, lawyers have better ideas now to manage files and structure a deal, knowing the court has power to spread costs across all group members. For the courts, it reaffirms their supervisory power to balance justice, fairness, and public policy concerns when managing large class actions. The judges will have to scrutinize founder commissions and ensure they are proportionate to the risk taken. No more rubber stamping. And for class action members, it means more predictability and fairness. Everyone who benefits contributes, and no one gets a free ride. It is important to note that the court in Kane's decision acknowledged that the prohibition on contingency fees was subject to further legislative intervention. For example, in Victoria, by virtue of Section 33ZDA of the Supreme Court Act 1986, the Supreme Court of Victoria has the power to make group costs orders that would allow plaintiffs' lawyers to be paid a percentage of the final damages award or settlement. So the biggest winners might be Victoria, as they will be the ideal place for all Australian class actions. Now looking at the practical side, what are the pros and cons from this decision? The pros, firstly, access to justice is preserved. Without founders, most Australians couldn't afford a large-scale litigation. Number two, equal contribution. CFOs ensure fairness, so no one freeloads on others' risk. Number three, judicial oversight. Courts retain control, preventing excessive founder profits. Number four, economic efficiency. Fewer duplicated cases and more coordinated claims. Now look at the cons. Firstly, there could be commercialization risk. Funding may become too profit-driven, turning justice into a market product. Secondly, there could be lower returns for claimants. If founder fees are high, class members get less. Number 3, there will be increased complexity. Lawyers now have to navigate tricky timing and approval process. And lastly, regulatory uncertainty. Each court will interpret fairness slightly differently, meaning some inconsistency could remain. Now, what does Kane and IMB case mean for the average Australian? It means if a bank, a corporation, or even a government agency wrongs a large group of people, there is still a path to collective redress. The door to justice remains open thanks to litigation funding, but it also means we are walking a fine line. We are trying to make justice accessible without turning it into a business commodity. This decision doesn't solve everything, but it's part of a continuing conversation about how to balance fairness, risk, and commercial reality in modern justice. So that's the Kane and IMB investment story, a case that redefines the future of class actions in Australia. What do you think? Should we go further and allow lawyers to take percentage-based contingency fees like the US, or does that cross the line into profit-making justice? Thanks for watching. I will see you next time.